Jazz hands, ladies and gentlemen, jazz hands, and welcome to another Saturday weekend review. I am your Lone Wolf Usul, and I am bringing you something rather special today, rather interesting, full of current events and interesting news stories. We're actually going to start today's show off with a year-old news story just to recap the events that got us to where we are right now this last week, and just keep watching. It's all pretty interesting. I included the video from yesterday just because I feel that's something that adds a lot of context to everything going on, and I think that we probably want to talk about that video together in relation to all the other cases. And ladies and gentlemen, it all starts right now.
And we begin this afternoon with the University of Michigan Police ending the encampment at the Diag. Thank you for joining us. I'm Glenda Lewis. Video posted to social media shows police using what appears to be pepper spray or tear gas on the protesters, forcing them to retreat. The officers moved in to break down the camp just before 6 a.m. this morning. Chopper 7 was over U of M as protesters were told it was time to pack up and head home. But 4 people landed up in Washtenaw County Jail instead. The tent encampment went up April 22nd. Police started with a hands-off approach, but when the protest was deemed disruptive, school officials say demonstrators were repeatedly asked to leave. So fast forward to May 17th, and a fire safety inspection failed, all leading up to today when police arrived just before 6 a.m. We do have team coverage following the major developments at U of M. We're going to begin with 7 News Detroit reporter Darren Cunningham live in Ann Arbor with what's happening now. Darren.
Yes, good afternoon, Glenda. Right now, as you can see, everything is back to normal here on the Diag, a scene we have not seen in about a month, as you mentioned there. University police tell me this morning officers issued 3 verbal warnings over a 15-minute period for people to leave before pepper spraying demonstrators and making arrests. University grounds crews power washed the Diag from morning until early afternoon, cleaning up remnants left by pro-Palestinian protesters and their encampment. University police say about 50 people were in the encampment just before 6 a.m. when they were asked to leave several times or risk getting arrested.
I think it was handled not in the best way. It was kind of done at a sneaky hour.
A number of people told us the timing felt sneaky. We spoke to several who came to the perimeter of the Diag either out of curiosity or because they didn't realize they couldn't pass through.
I think it's a shame. I think students have the right to protest on campus, and their safety shouldn't be like a concern. They shouldn't have to fear getting arrested or pepper sprayed. I supported what those guys were doing. In a statement to 7 News Detroit, University administration said it recognizes the importance of free speech, but they have a duty to protect all who use the campus. The administration says the clearing of the encampment was sparked by the refusal of occupants to remove fire hazards. On May 17th, we're told an inspection by the university fire marshal determined a fire would likely lead to, quote, a catastrophic loss of life. Because of the refusal, the university removed the encampment.
One of my kids is at another university where the university actually negotiated and is willing to actually take a vote on divestment issues in the fall. So that's Brown. And so I know that there are a wide range of things that universities can do, and it's the lack of creativity that goes into the way they've handled it here is just mind-boggling.
I never felt unsafe around it, being a student here, having to walk past it every day, and it just seems like it was a bit of an overreaction. And especially all this with the not letting anyone get within like 300 feet of where it was is kind of ridiculous.
Right around 1:15 this afternoon, University police reopened the Diag, removing the caution tape.
2 questions. 1, did the problem get fixed? And if the problem did get fixed, then why are you kicking them out? 2, why are you pepper spraying and it's a forceful move, dude. You know what I mean? They're just trying to kick people out because they're trying to make business continue. That's it. It's a money move.
Where to from here?
I mean, I think it's sad that the university didn't want to have conversations with people. I personally wouldn't be surprised if something else popped up.
All right, I stopped a considerable number of people. Only those sympathetic to the encampment offered an opinion. I reached out to the University Public Affairs, as I previously mentioned. I also asked if I could speak with the president, if I'll be able to interview him. However, I was told he is not available. But the university's statement went on to say, quote, the disregard for safety directives was the latest in a series of troubling events centered on the encampment, end quote, and that protests are welcome as long as they don't endanger the community, disrupt university operations, or violate the law. Live in Ann Arbor, Darren Cunningham, 7 News Detroit.
All right, Darren, thank you. We do have our team coverage continuing at the Washtenaw County Jail, where demonstrators were released from custody just hours ago. A total of 4 protesters were arrested by police this morning. Several different charges. 7 News Detroit reporter Brett Cast is hearing from people who were arrested.
Well, it was a pretty large crowd gathered here outside the Washtenaw County Jail where those 4 arrested protesters were being held. And once they finally got released around 1:30, the crowd erupted in cheers. A roaring welcome as 4 protesters released from custody, more than 7 hours after police began clearing the month-long encampment at the University of Michigan Diag.
Free Palestine. Get our money off of hands off the Middle East.
Assad was one of those protesters arrested. He says he's a 26-year-old graduate of U of M from Dearborn Heights, uncertain what charges he's now facing.
It's far more important to center the people in Palestine right now than to center any of this nonsense.
Shortly after the encampment was cleared, the protest moved to the Washtenaw County Jail. There, the group continued what they had been doing at the Diag, playing drums and dancing, gathering on the lawn to listen to speakers, some seeking shade around the building, bringing food and water, ready for the long haul.
I had pepper spray all over me in my eyes since 6 a.m. I just got washed up just now.
Rhiannon Wilson was also arrested and held in the jail. The grad student and research assistant said she's now facing felony charges for resisting and obstructing a police officer.
Honestly, it's just pretty shocking as a student and employee of the university doing what I understand to be a protected First Amendment activity for what I believe in.
Willow camped for nearly 30 days and says she was told she's now banned from campus. With the encampment now clear, those protesting outside the jail and those held inside vow to keep their fight going.
This is why we stand up. When people are under attack, when there is injustice, you stand up and fight back.
And the group says 3 protesters were privately taken to the hospital, but most have since been released. In Ann Arbor, I'm Brett Cast, 7 News, Detroit.
Day District Court for County Michigan is now back in session. The Judge Jay, you may be seated.
Court does call the case of the people of the state of Michigan versus Henry McKean Shapiro. I'll call that case separately.
Good afternoon, Your Honor. Right with you on behalf of people.
Lauren asking on behalf of Mr. McKean Shapiro, who stands to my left.
All right, this is the people's motion regarding revocation of bond. Go ahead.
Thank you. Your Honor, on September 17, 2024, this defendant was given a set of bond conditions. One of those conditions was that the defendant could be on the U of M campus only for the purposes of attending class and or for the purposes of employment. On March 28, 2025, which people have articulated in their motion, the defendant violated that specific bond condition. He was photographed in Angel Hall, putting up flyers at approximately 10:25 a.m. He did not have a class in Angel Hall. He was not working at Angel Hall. He had no purpose to be there, and therefore the people believe that it was a violation. Attached to our motion, we have attached several documents. One was the bond order, which outlines the conditions that he was governed to by this court. The others were photographs of the defendant on March 28th at Angel Hall, putting up those wanted flyers. We also attached the defendant's class schedule. His class schedule indicated that he did have class that day at a different building, that being the MLB building from 9 to 10. And after that, according to his own response, he had a quiz that he was supposed to take, but that quiz was also in that same building. He had no purpose to be in the Angel Hall building at all. He was not there for class. He was not there for the purposes of employment. He was photographed there putting up posters, but I really don't even think that is the issue. The issue is that the bond conditions of this court is that he's only supposed to be on campus for the purposes of employment and or class. And clearly, the photographs indicated that on March 28, 2025, at approximately 10:25 a.m., he was not doing either of those things. And so, Your Honor, with that, we request that the court does find that there is a violation, and how the court needs to deal with the violation, we need to discuss.
Thank you. Saskia.
My client is acknowledging that he did violate the bond conditions. Although he was
on campus for class, and he went there to study. He does acknowledge that he had no purpose to be in that building, although he was there to sing Friends for a moment. So although he was there and he was there during a break, he was not supposed to be in that particular building.
Accept the admission of the defendant to the bond violation. Mr. McKean Shapiro, anything you want to tell the court before I impose sentence?
No, thank you.
All right. Well, let me just tell you this, sir. Throughout this entire case, I've been taking it at a pace, particularly so that you know, recognizing that some of you as students were set to graduate. You were one of those. I either have to believe that you just through some willful and wanton reason just decided you wanted to violate this court's order. And in that way view you as one that I certainly have to protect the public. On the other hand, I almost want to think about you as just being stupid. And I hate using that word, but this is just absolute stupidity. When I saw the photographs of what you were doing, and understand, I'm not going to issue a sanction because of the content of those flyers and the speech that may be in that, as vile as it is. I'm not doing it for those reasons. I'm doing it because you have to understand that in some way you have to conform to rules. Somehow or another, from the very beginning of this case up until that date, you were able to do it. And I don't know how you just lost your mind that day and just decided you were going to do something else. I told your counsel, and we were back discussing it in chambers, and I'll just make it real clear that upon seeing that, unless you gave me some good explanation, I was just going to send you. You were just going to sit till this case ended. You need to thank your attorney that she was able to convince me that maybe that wouldn't be the best thing in the world. Because I don't issue orders I don't intend to enforce. You violate them, I'll hear you out. I'll allow you that due process to be able to explain to me what happened. I think as Mr. Macklin, when he was arraigning before, I have difficulty sometimes with these orders regarding the U of M. I grew up in Ann Arbor. I understand that sometimes you can be walking around, you're on city property, the next thing you know, you're on university property. I get all of that. That wasn't this. You were someplace you weren't supposed to be, quite frankly, doing something you shouldn't have been doing given the circumstances that you're in at this time. Where is your graduation going to occur?
One is off campus, and there's another in the big house.
Where?
The Michigan State Theater.
But that's a sanctioned event.
I don't believe it's university property, though.
Okay, amen. I get that. But the event is being put on by the university, right?
Correct.
And in here lies the problem. Tell me how I can trust you to behave yourself, not only just on university property, but at any university event.
I have no intention of attending that event for any other reason than receiving my diploma.
Why am I supposed to, how am I supposed to believe you? See, that's what the problem is here. You're asking me to trust you. How am I supposed to trust you?
At the moment of that I received my diploma, I'm willing to, I will not have any more contact with the University of Michigan in any regard.
That's the only ceremony you were attending?
That was the only one I was planning on attending.
So you are not going to the one at the stadium?
No.
The other thing that your attorney convinced me not to do, because quite frankly, I was concerned certainly about those of you that were graduating initially when this case came along. Very concerned and making sure that you got there. But your behavior, in my mind, almost had you forfeit that right to be at that graduation. Basically, just sort of flushing down the toilet, if you will, the symbolic representation of the time that you spent. But your attorney pointed out something to me, because your dad's here. And I guess sometimes what kids don't realize is you're getting that piece of paper, but you're walking across that stage is more for them than it is for you. That's what you jeopardize for your parents. So the only reason that I'm even, and I don't know your dad, I never met him, wouldn't be able to pick him out of the crowd that's out there, but I'm just going to tell you something. The only reason I'm fashioning something that allows you to attend that graduation is for your parents.
Much appreciated, Your Honor.
They shouldn't suffer because of your stupidity. Because that's something they never get back. But you're going to have to pay a consequence for it. Everybody else here has been able to conduct themselves as best I know in a fashion to comply with the court's orders. You did not. Your attorney has convinced me that sending you to jail for 10 days through the graduation commencement weekend would be unduly burdensome to you and your family. So here's what I'm going to do. I think it appropriate that you spend time in jail for violation of the court's orders. And I do consider it not just a violation of that order, but I consider it a willful violation that you did. You knew better. So, Mr. Allen. So it's going to be the sentence of the court. You're going to spend 4 days in the Washtenaw County Jail.
This way.
Thank you, sir. Oh.
Shame.
Oh, stay here. Stay here.
Stay right there, sir.
Just face forward. Good. Good.
Do you have anything on you?
Hmm?
Do you have anything on you?
Put your hand.
No.
You can put your hand.
You're going to spend 4 days in the Washtenaw County Jail. I'm going to release you after those 4 days. So that you know, today counts. So it's not like 4 days from today. Should be out Sunday. You'll be placed on a GPS tether for your location to make sure that you do not enter any University of Michigan property. So be careful when you're walking, once you're out, when you're walking around, that you don't just stray there, because particularly down where your commencement is, you know what I'm talking. There's areas that are U of M property. You understand that?
Understood, Your Honor.
Okay. Defendant is remanded. It's released on that day. Counsel, because of just the timing of it, so that, because Normally, I would say that he can't be released without the tether. But because of the timing and only giving him 4 days and not giving him 5, he would be released on Sunday. Community corrections is not open. I'm still going to allow the release at that time. And then on Monday, he's going to have to report to community corrections to get the tether.
Okay, what time do they go?
8.
Yeah, 8 or 8:30.
8 or 8:30. Well, I'll just put it this way. He'll have to be there before noon on Monday. All right. Has that woman been removed from my building? She out of my building? Folks, there's still the argument on the disqualification motion, which certainly I will hear. They're gonna have to process him in and then get him back in here. So I'm gonna let that process occur, and I'm gonna take a brief recess. And then we'll come back and. Folks, before you get up, would you have a seat, please? Understand something. All of these things are difficult. You may not like the court's rulings. A lot of thought has gone into them. I need you to also understand that while that defendant did what he did and he took responsibility for it, I also have 6 defendants that have properly followed the court's orders and have not placed themselves in any jeopardy. What happened in that case is he did it to himself. But anybody that wants to have an outburst, you can have an outburst all you want, but you're just going to be removed from my building. I'm not going to tolerate it. It's not fair to these defendants as well as Mr. McKinney Shapiro to have their case properly heard. So I'm going to expect that everyone will conduct themselves in conformity with it. Court stands in recess.
Rod.
Welcome back. A civil rights attorney based in Michigan says he was targeted by U.S. Customs and Border Patrol agents because he represented a pro-Palestine protester. Amir Makled says he was detained while returning from an international family vacation for about 90 minutes at the Detroit Metro Airport, and while there, in that detention, brief though it was, pressured to turn over his cell phone. Now, in response to this accusation, the Assistant Commissioner for U.S. Customs and Border Patrol said this, and I quote, "This lawyer's accusations are blatantly false and sensationalized. Upon entering the country, he was flagged and referred to secondary inspection, a routine, lawful process that occurs daily and can apply to any traveler." It goes on to say, and I quote, "Claims that this was an attack on his profession or were politically motivated are baseless. Our officers are following the law, not agendas." Amir Makled joins me now. Amir, it's great to have you with us. Thank you. You heard that response from the administration. You're familiar with it. What's your response to that characterization?
Well, thanks for having me. I say that this is not a routine stop. When I arrived at the border crossing, the Customs and Border Patrol sent me in for secondary screening, and they used an acronym called TTRT, which standed for Tactical Terrorism Response Team. An officer came to me wearing plain clothes, refusing to identify himself, and knew about my travel history, knew about my profession, and knew about some of the recent high-profile cases I'm litigating. This wasn't a routine stop. This was a targeted stop. And the fact that they brought up my profession and they brought up the recent high-profile cases involving University of Michigan protester cases, I'm representing a student named Samantha Lewis. She's charged with a felony for resisting a police officer for the civil rights protest she engaged in on campus. These are the reasons why I believe this was a politically motivated and an intimidation tactic by the Customs and Border Patrol agents.
And Amir, as I understand it, there was a photograph. They looked at the photograph, brought you to the secondary detention space, and then started talking to you about what they knew about you. Is that true?
That's correct. They knew my travel history. They knew that I was an attorney. They knew about my my caseload, and they demanded to see my cell phone. They handed me a pamphlet, and they indicated to me that at the border, which I was familiar with this statute, at the border, the government can seize a telephone. I'm not obligated to give them the password to my phone, but I also didn't want to leave the meeting or leave the airport without my device. I knew that as an American citizen, they couldn't deny me entry into the United States, so I wasn't concerned about that. However, I was concerned about leaving without my cell phone device. Then they demanded that I unlock the phone and hand over the information. And I explained to them, you already know that I'm an attorney. You already know that I'm representing individuals, and a substantial amount of my work is going to be on my cell phone. I'm not going to hand over this device and breach my fiduciary duty to attorney-client privilege. And that puzzled this agent, which required him to go get some supervising advice. A supervisor came back maybe about 20 or 30 minutes later and handed me a legal pad. He said, why don't you write down everything that you believe could be privileged information in your cell phone? I said, this is a futile exercise. I've been an attorney for over 10 years. I've got thousands of emails, thousands of text messages, thousands of communications with clients and hundreds of files in my phone on my cloud. It's impossible for me to identify what could be a privileged communication or document in this setting. And at that point, they said, look, either we're going to take your phone or you're going to comply. I said, well, what is it that you're looking for? They said, show us the list of contacts in your phone, and then we'll allow you to have your phone back. So I acquiesced. They said, sign a document, and in this document indicate that you're agreeing that we can see your contact list and that your contact list is not a privileged information. I agreed. I wrote it down, and they went through my contact list at that point. Now, how they dumped this contact list, whether it was done through a external device or whether they manually scrolled it, I'm not sure. They took my device away from me for about 7 or 8 minutes. When they came back, they had a list of questions about individuals who were in my contact list, about 5 or 6 names. And at that point, I knew this was getting into a much deeper dive and a much more targeted investigation and line of questioning. I pushed back again. I said, look, if a contact is in my phone, that person is going to be a family member, a friend, or a client. And that's all the information you're going to get out of me.
Amir, I've got about a minute left, and I'm up against a hard break, so it's just a minute. What do you believe are the dangers in this scenario for you and attorneys like you?
I think it's a pattern of targeting. I think that this will cause a chilling effect and set a dangerous precedent. If attorneys, if journalists, if activists are being flagged and questioned at the border based on who they represent or based on what they believe, it creates a chilling effect on speech, association, and advocacy. We've seen this administration going after attorneys. I think it's important that we don't discourage people from traveling, from organizing or dissenting. We all have to follow what we have under the protections of the First Amendment.
And very quickly, your family was allowed to go through. You alone were detained.
Yes, me alone. I was alone detained, which made me feel a lot better because when the kids were gone, I can deal with the government confrontation. I do this for a living. I don't have a problem talking to law enforcement.
Amir Macklin, I appreciate the time. Thank you very much.
Thanks for having me.
Court for County of Washington, State of Michigan is now back in session.
You may be seated. We can bring him out. Court does call the cases of the people of the state of Michigan versus Willow et al. Counsel, please state your appearances. Why don't we start over there?
Good afternoon, Judge Reichler on P83665 on behalf of the
Go ahead.
Thank you. Oh. And I'll also stand in for Mr. Hadar on behalf of Mr. City.
Got it. Okay.
Thank you. Good afternoon, Your Honor. May it please this court, Amir Macklin representing Ms. Samantha Lewis, who's present.
Good afternoon. If it please the court, John Minnick appearing on behalf of Avi Taknafram, who is here via video, and also with the court's permission and with the consent of Mr. Kosler, standing in for Stacey McNulty on behalf of Mr. Kosler.
Is that correct, Mr. Kosler?
Yes.
All right. Very good. And
Good afternoon. Jamil Kuja appearing on behalf of Mr. Muller.
Lauren Aston on behalf of Mr. Keisha here.
all right, thank you. And Mr. Tetchafrom, you'll need to turn your camera on, please, sir. All right, thank you. All right, this is the defendant. Well, let me try to clarify one thing from the beginning, because it's defendant's motion to disqualify the Attorney General. All parties except one joined. And I just want to make sure, was this argument on behalf of also Mr. Hader?
Your Honor, on behalf of Mr. Siddiqui, standing up for Mr. Hadar, if the court would accept our oral motion to join.
All right, very good. Actually, to make things a little bit easier if he's joined. All right, very good. All right, now that we've done that, who is going to begin the argument?
I will.
All right, go ahead, sir.
Thank you, Judge, and may it please this court. Your Honor, we're here today on the principle that an impartial justice demands that the prosecution of my client, Samantha Lewis, and her fellow student protesters be handled by a neutral third party and not by the Department of Attorney General and through our Attorney General, Ms. Dana Nessel. It's our position that that office has already demonstrated both actual and apparent bias towards pro-Palestinian protesters. Let's be clear here, Your Honor. This is not a motion rooted in politics. It's rooted in the law. It's rooted in our Constitution. It's rooted in the fairness that we're seeking from this honorable court and the due process that we're entitled to. Judge, it's rooted also in the basic expectation that prosecutors are ministers of justice and not political actors. And the reason why we bring this up is, and I'll begin with, really an exhibit that the prosecuting attorney and the Attorney General's office attached to their response to our motion. A letter in May of 2024 directed towards the General Counsel of the University of Michigan, Mr. Tim Lynch. In that letter was a solicitation of these criminal prosecutions. In fact, and I quote this letter, that it's written that by Ms. Hageman Clark, who I believe is going to be arguing for the prosecution in this case. It says, I write today to offer the DAG's assistance with investigating and prosecuting any cases that arise from recent demonstrations on U of M's campus. That's a direct solicitation. It also goes further, Judge, and this is really very interesting to the defense, that they indicate, I would also note that our department has specialized expertise in the intersection of First Amendment free speech rights in the context of criminal prosecution. Judge, they're telling the University of Michigan Attorney General that we're experts in the criminalization of free speech. That's what that sentence indicates to me. And the Attorney General—
fair. I mean, I don't know that that's what it's indicating. I mean, as I read it, and I'll let you certainly argue, counsel, but I don't know if that's fair. I mean, what it seems to me it's really saying is that sometimes when you're dealing with the criminal law, there are other constitutional implications. One may be the free speech, and that trying to sort all of that out, that we're experts in dealing with. I mean, that is just as fair a representation, isn't it?
The court can look at it in that light, Judge, but I'm asking the court to look beyond the narrow scope of this and take a look at some of the other factors that come into the totality of the circumstances of this solicitation for this type of work. Your Honor, it's true that they've bypassed local prosecutors, city attorneys, county prosecutors who at the time of this encampment had foregone the opportunity to bring criminal prosecutions and any pro-Palestinian protest activity. Peaceful protest conduct wasn't prosecuted by anybody.
Can I just stop you there for a moment?
Yes.
Because that was one of the things for me, and I would certainly give the Attorney General an opportunity to respond to this, as I'm reviewing all of this, the letter, there are certain assumptions being made about what the local prosecutor did or didn't do, right?
I agree with that.
Your brief, and it's kind of cited in the response from the people, and then also cited in your reply to their response. What evidence or anything do I have of what Mr. Savitt did or didn't do?
Your Honor, I can't stand before Your Honor. I cited public articles that had some statistical data that was presented in the Guardian and in national publications. I didn't subpoena or FOIA any of the declined prosecution requests where warrants were denied or things of that nature from Attorney Savitt's office, prosecuting Attorney Savitt's office. What I do know, and this is proof that this is a letter from the Attorney General's office, and this is in an offer to take up some of these cases. And it writes, and I'll bring it into this argument, Judge, that Washtenaw County Prosecutor Eli Savitt recognizes that his authority is confined to Washtenaw County. He is comfortable with the DAG overseeing these cases based on his jurisdiction being limited to only Washtenaw County, as if this was an acquiescence by the county prosecutor saying that it's okay, we're in agreement, we're comfortable is the word that's in this letter, that the Attorney General's office can take it. Now, when we go further to some of the conduct of the Attorney General herself, Judge, we didn't know that there was going to be an appearance of impropriety or an implicit bias until the Attorney General's office themselves filed a recusal from a high-profile case involving Arab American elected officials in Hamtramck. In that specific context, and it was written, and I attached that in our initial motion, that she publicly rallied against them and admitted that critics had alleged bias against Muslims and Arabs in her handling of other pro-Palestinian matters, which was a reference to this specific case. And that's what she used, the standard, when she asked a court to remove her office from being a prosecuting attorney in that case, Judge. And so
before you get into that issue, I want to just back up to the letter again, because I've got a lot of questions regarding that. Is it the defense's position that Mr. Savitt declined to prosecute, then the AG took up the cases, or that these cases are just sitting there, that nothing is happening with them, and that the AG takes them out? Because those to me would be very different things.
I can say, as an officer of the court, in my investigation of that specific question, I spoke to members of Mr. Savitt's office. And my understanding was that it's not that they declined to take these cases, that the Attorney General's office offered to take these cases, and then they didn't have a problem with that opportunity to have something that's not on their docket anymore. You know, they didn't need to have this workload. And so when the Attorney General's office came in and made this offer to the university, the local prosecutor, which would be the normal form of jurisdiction in this case, in any trespass case, Judge, this is a trespass case and a resisting and opposing case. These are state cases that are filed by local county prosecutors or city attorneys, if they're just misdemeanors. That would be the norm. But Eli Savitt's office, from my understanding, didn't say we're not taking these cases or declined warrants on these cases, only that because the Attorney General has asked to take on this investigation and the potential prosecution, that they would acquiesce to that request.
Okay. And is if that's true, is there a writing which evidences that?
Not that I have discovered as of yet.
Okay, that's fair enough.
And Judge, further, the letter is arguably soliciting for criminal prosecutions. I mean, that's what it looks like from my perspective. And it's from a public university, which is a third party. And the Attorney General's office is actively offering to investigate and prosecute any cases that arise from recent demonstrations, quote unquote. Those are the words used in that letter. It has potential ethical concerns. Prosecutors are supposed to remain detached, we're supposed to remain impartial arbiters of justice, not proactive hunters of politically sensitive cases, especially when local prosecutors are available. It undermines the confidence and the fairness of the neutrality of that office. And when I go to the next point, Judge, of recusing, the Attorney General recusing themselves from the Hamtramck investigation and case, I think that shed light on that the Attorney General herself believed that there was an appearance based on appearing biased, warranted recusal in that case. And now they claim that they have neutrality here. And the same criticisms have been raised. What's good for the gander is good for the goose. You can't go in that argument in that jurisdiction and say that we don't want to have an appearance of impropriety, and so we're asking for appointment of a special prosecutor, and in the same breath come over here and say, no, the appearance of impropriety is not the standard. The appearance of it's actually been MCR or MRPC 1.9 doesn't say that appearance of impropriety is the standard anymore. You can't make that argument now and say in her petition for special prosecutor in the Hamtramck case, she specifically said, to avoid even the appearance of impropriety, justice can be more aptly served by the disqualification of the MDAG and the appointment of a special prosecuting attorney. Your Honor, they don't get to make that argument on both sides of the coin. They can't say in that case that that's not the standard, then come over here and say, well, Judge, don't worry about the appearance of impropriety anymore, because that's not what the court rule says. There's case law, however, that does support. And I cited the case law, Judge, People versus Paffel, which is 246 Mishap 282. And in that case, it is, a appearance of impropriety standard. Your Honor, these are selective prosecutions. These are situations where this prosecuting attorney is attempting to circumvent their own political opinion and bringing these prosecutions. Our Attorney General has filed a response indicating that they didn't participate in demonstrations against pro-Palestinian speech, which is unlike what she did in Hamtramck, where there was some demonstration about not having flags in support of gay rights being flown in Hamtramck. And she spoke publicly about that issue, and that's why there's a distinction in this case. However, Judge, I say that's not true. She was very, very public about her response to our Congresswoman, Rashida Tlaib, and called her protest activity as anti-Semitic. She has never said that pro-Palestinian speech is potentially she has never said that pro-Palestinian speech is allowed under the law. She's never spoken in support of the ability to free speech on that issue. She's only always criticized pro-Palestinian speech in the media and in meetings with people and individuals. So that gives us another argument. Now, also in their response, Judge, they compare this case to other scenarios of different race. And they believe in the belief and the like to show that removal is not proper when the prosecutor and the accuser are of different faith and belief. There was a sentence in their response that spoke as to the Jewish faith of our Attorney General. And I'm saddened that that was a response that they gave, because that's not the position of the defense by any means at all. And I think that argument takes away the merit of what we're trying to accomplish here. They're mischaracterizing the defense's argument and trying to distract from the real issue. The Attorney General's conduct it's not about her religion. It's her conduct that gives rise to the concerns about bias. It's not her identity that necessitates the recusal in this case at all. But the public statements she made in condemning pro-Palestinian advocacy, And the example that we cited is when she called Rashida Tlaib's protest speech as anti-Semitic. Her disproportionately aggressive charging decisions. She's charged these students with felonies. Other jurisdictions didn't charge, and every case stands on its own 2 feet, Judge, I could say that. But in Wayne County, Kim Worthy's office filed 0, none, not a single case was prosecuted in Wayne County. In Eli Savitz's jurisdiction, I think maybe a small handful of cases were charged. None of them were felonies, from my understanding. Now, and then you add in the identical case of a situation where Arabs and Muslims are targeted for, in the Hamtramck case, and she herself acknowledged the appearance of impropriety. They brought that issue up. It's not something that just we pulled up and said it. You know, we made it up. They brought that issue up first, Your Honor. We didn't know that there could be an appearance of impropriety until she said she believes that she could be biased or appear to be biased. And so, if you feel that you can be biased in Hamtramck, you cannot be impartial here. And that's the major point in this case, Your Honor.
Can I just, I think, and I'm relying upon my memory, but I state what happened here in Washtenaw County. All of the felony PCs come past my desk. So I seem to recall, unless that there were cases that were filed by Mr. Savitz's office that ultimately, I think, were resolved. I think they initially started as felonies and then were resolved as misdemeanors. I'd have to double check that.
I think the court's right in that recollection. I think that you're right, Judge.
And I think that's what happened. And I hate sort of bringing you back, and I want to make sure that I get to your full argument. That's why I'm trying to figure out, there were those cases that I'm recalling, and then there are these cases.
Your Honor, in those cases, they were settled into diversionary pleas. They were settled into pleas under HIDA with no convictions. And they were not brought with this type of vigor.
Well,
yeah.
Right.
Yeah.
But all that aside, what I'm getting at is I'm trying to figure out if those cases were brought and then resolved, however they were resolved, but they were brought, what happened with these? I mean, because my understanding is they all were hit at the prosecutor's office roughly the same time. I think co-counsel may want to.
There were 4, 2 misdemeanors under HIDA. Others got straight diversion dismissals. Right, and it was very early on in the piece. There's no insistence on these statements.
That's correct. Yeah, Your Honor, Mr. Kuja, who was counsel on those cases.
Hold on 1 second. Right.
And Mr. Minnock.
That's exactly what they're saying. Okay, go ahead.
The brother counsel, Mr. Kuja and Mr. Minnock, were both involved in those in the defense of those cases, and are acutely aware of the interactions more than I am, Judge. But Mr. Kuja recognizes that, and told me, Your Honor, just now, that 4 of those were done at the early stages, PCC, where they offered diversion and pleas under HIDA. And I want to circle back on the people's argument about their willingness to participate in plea negotiations in this case, Judge. In this case, the court really doesn't usually like to get into plea negotiations, and I don't want to get too far into that, but they brought it up, Your Honor. That to me doesn't make it more, the people are trying to make it appear that they've been more lenient or have done more to favor our collective clients in this case by engaging in potential plea negotiations, when they shouldn't have brought these felonies into the first place from our defense position. But you can't just charge students with felonies and say, oh, well, we're engaging with plea negotiations, and so we are acting in good faith and we're going to be lenient towards you. That leniency does not excuse the initial and politically motivated decision to charge these cases. So they brought that up, and I just want that to be noted for the record, Your Honor. And then they're demanding certain things in a plea negotiation, which I don't want to get too deep into in front of Your Honor.
Thank you. Well, counsel, again, I realize this is difficult question to answer, but something I think that plays certainly into my analysis as it regards where these cases were.
Your Honor,
Because so I had, and I was correct, my staff let me know, I was correct that there were these 4 felonies, and I think that's what Brother Counsel was indicating to you.
That's right.
There were these 4 that came through. They were resolved in some way that there were misdemeanor. Now,
yes, under advisement of diversion, which didn't have a
Right.
conviction at all.
That's factually, I don't think anybody can dispute that, sir, right? At the same time, there are these cases, right? Or cases like them coming in. And what I'm trying to figure out, and maybe this may properly be addressed to the Attorney General, or maybe Mr. Savage's office, is what happened with those cases? Like, maybe put a better way, is there were those 4, and then I have these 7, and there are 2 more floating around someplace else, but my concern are these 7. These 7 take a different path, right?
Right.
And so why is that? So sometimes it can happen where a local prosecutor says, we are not prosecuting these because for X reason. And then they send it up to the AG's office for reassignment to someone else. Or where they say, we're not doing these, and the Attorney General then takes and they prosecute a case. Okay, and I have those come through all the time. What are you believing? As I listen to your argument and I read your argument, you're saying that that did not happen.
What I'm saying happened, Your Honor, is that Dana Nessel's office went and picked these cases up. That's our position. Not that Prosecutor Savage was unwilling to prosecute them or didn't or declined them. This Attorney General's office went and solicited this work and picked up these files, these specific defendants.
Okay, so if that's true.
Because this letter is dated May 24, Your Honor, which is only 2 days after the encampment, I believe. Am I right? 21? 2022?
Okay, so if that's correct, what legally would prevent the Attorney General from doing that?
Your Honor, that's the ethical conundrum that I see, Judge. I think legally that shows under the court rule that we've cited in the case law, in conjunction with the other issues that I've raised in the brief, that this is a selectively prosecuted case. This is not done as a neutral and impartial minister of justice that the state is, supposed to have. This is somebody that cherry-picked a case and decided, I'm going to be the one who takes this on because it is my office that has a specialized expertise in the intersection of free speech rights in the context of criminal prosecution, which I already told you what I believe that means is I like to criminalize free speech.
So you're saying that if the AG's office did that, that there is an ethical issue. I'm going to have to say I have some qualms. While I know what you mean, I have some qualms about the use of selective prosecution because that can mean a different thing in my mind. But I think I get the concept of what you're putting forth when using that phraseology. All right.
Thank you, Judge. Okay.
Right.
I agree. We're on the same page, Your Honor. Yes. Your Honor, that's the totality of my argument today, Your Honor. Unless the court decides that we should have an evidentiary hearing on some of these unanswered questions, I'm open to that opportunity as well if the court would like that.
Good evening, Your Honor. Danielle Hageman Clark on behalf of the people. I'll start with the issues that the court has raised. Since I'm the one who actually wrote that letter, I'm not criminalizing free speech. It is as the court has said. We have a specific knowledge in our department because it houses the Solicitor General Bureau that deals with issues of First Amendment rights to free speech. And when you then add on criminal context, it becomes more complicated. I wrote that letter to Mr. Sabat after I spoke with Mr. Sabat and said to him, hey, we'd like to help you with these cases. Are you interested in that? And he said, yeah, because we weren't just investigating what happened at U of M's main campus. I think we all know we were investigating something much bigger and events that had gone across multiple counties. And so we are the only prosecutorial agency in this state that has multi-jurisdictional authority.
Did you indicate that you sent a communication or some type of letter to the prosecutor?
Oh, I talked to him on the phone, Judge.
Okay, go ahead.
Talked to him multiple times on the phone. Because contrary to public belief, the AG's office doesn't have an opportunity or a legal mechanism to simply come in and say, get out of the way, we're taking that case. There is no statute, there is no law, there's no case on point that says the AG's office can do whatever they want. And we don't operate like that. As the criminal bureau chief, I offer our assistance to all 83 elected prosecutors on cases from anything as simple as a misdemeanor all the way up to first-degree murders on a daily basis. It isn't selective prosecution, although I do take exception to that, because quite frankly, every time a prosecutor exercises their discretion to put pen to paper and charge someone, it's based on a review of the facts as applied by the law and whether or not we believe we can prove that case beyond a reasonable doubt. Some would say that is selective prosecution because not all cases get prosecuted. Oftentimes cases do get denied by local prosecutor's office. And our policy in our office is not to act as an appellate review to those 83 elected prosecutors. But if a local law enforcement says, hey, you know what, we think that maybe they just missed the ball on this one, or this prosecutor didn't look at this, or we develop more evidence, we want to bring it to your office to take a review. We do that every single day. And we've done that with cases in front of this court. The Isaiah Williams prosecution was one that this court heard multiple days of testimony about, where a young baby was kidnapped and murdered by a woman's boyfriend back in the 80s. Washtenaw County Prosecutor's Office looked at it and said, you know what, we're going to pass on that. And so the Ann Arbor Police Department brought that to our office. We charged it, we brought it to exam, we ultimately took it to trial. Mr. Williams has been convicted. So it happens every single day. In terms of the SPA process, there seems to be a fundamental misunderstanding of how a request for a special prosecutor works. It has nothing to do with going to court. It doesn't get filed with a court. It happens by each one of the elected prosecutors, and it happens with the AG's office, where they put together the SPA petition and they say, in this case, the facts of the Hamtramck SPA petition and the alleged voter fraud and ballot harvesting could not be reviewed by our office because the Attorney General protested those specific defendants that now they're asking the AG to take a look at to decide whether or not they've committed criminal events. Her protesting them publicly and saying, you, Mr. Suspect 1, you, Mr. Suspect 2, you, Mr. Suspect 3 and 4, I publicly called you out, and now I'm being asked to take a look to review whether or not I should be charging you. This is a case that I believe, as the prosecutor, is rightfully placed somewhere else.
But Madam Prosecutor, is
Yes.
is that really indeed the case?
Yes.
When I look at use in the petition, there's specific mention of the U of M demonstrator.
There is. Yep.
Well, why, and also then by the press arm of the Attorney General's office there, but it's particularly in this, so why is that mentioned? If you're saying it's as simple as what you're saying, that I've been critical of these individuals, so I can't do this, I can't do that. Why are these cases even mentioned in?
Because if you look at paragraph 6 on page 2, it says she has been criticized for her prosecutions of pro-Palestinian protesters at the University of Michigan. And what always fails to get added into this discussion is this piece. Critics have alleged, albeit without justification, that these prosecutions were brought due to bias against Muslims and or people of Arab descent. It is likely similar that the same criticisms would follow any prosecution in Hamtramck. And I would say that this criticism of her bias has been a noise, and it has been a distraction to what are the real issues in this case, which is getting to whether or not these defendants have committed criminal acts. That did not need to then go spill into another prosecution involving people of the Muslim faith. And I will admit that those folks are not of Arabic descent. I was mistaken when I said that. It's my understanding that they're actually Bangladeshi. So I clear the record on that. The difference between this spot and the instant facts is the AG's own behavior. And defense wants to say that it is analogous to AG Nessel calling out our congresswoman, when it's the AG's position and our position that she simply clarified a misstatement. It is this phrase, from the river to the sea, that people differ in how they view that, whether it is viewed as a pro-Palestinian belief that the Palestinian folks have a right to live free, or if it is being used as a full destruction of Jewish people. There are different opinions about what that means. And that is what AG Nessel was calling Rep. Tlaib about, calling her out about. But to say that she has gone out of her way to criticize these defendants, she has not. There has been no conduct by the AG other than to say that lawful, peaceful, permitted protests are not against the law. And that she encourages folks to engage in that behavior, but that is not what we have here. And that is why these defendants.
But why even put paragraph 6 in? If it's as simple as you're saying that there was criticism of these particular officials in Hamtramck, why even mention it? Why even mention these cases? Because she could have, if I buy what you're saying, because she was critical of the individuals in Hamtramck, the individual council people, without mention of any of these demonstrations, she could have recused.
Yes, she could have.
Then why mention it?
Because the noise around this and them calling her out consistently for being biased without justification would have followed her into the Hamtramck prosecutions. And so I believe.
No, what I'm saying is she says, I'm handling cases. If she says even there's some unfounded notion because I'm Jewish that I feel this particular way in this and may feel that way in this case, or because of their view regarding gay rights, I may feel this way in this case in my participation in the rally. And I feel then, and I'm not going to say it as articulately as it probably should be said, but I feel that based upon that and the perceived notion of bias that may follow from those activities, those statements, those things, that I am going to recuse on the Hamtramck case. Except this is different because in this statement, as well as in the public statement that's made, they bring this in as part, these cases here, in as part of the justification for why I'm recusing.
Yeah, so perhaps my spa was inartful. The recusal is based upon her behavior protesting those folks. I brought notion.
Yeah, but that's not what this says.
It does say that, though, Judge. It says that on paragraph 5, and it's undisputed that she's been critical of policy positions taken by the Hamtramck City Council. It's in there first, even speaking at a rally against these particular suspects. It's in the paragraph immediately preceding 6 and 5. It is the primary justification for why the refusals.
And why even have 6? That's my problem. My problem here is I don't think, and maybe for this court, it would be a much easier decision had the defendants brought this motion and there weren't these statements on behalf of the Attorney General's office that even mention these individuals. Because frankly, from my standpoint, I would have said, okay, Hamtramck's Hamtramck, we're Washington County, this is these cases, and we're done. But it's really isn't it really the Attorney General's own statement and confluence of these cases and who these people are that make this an issue?
Yeah, I would say that I should not have added it. Standing here before the court today, if I had to do it over again, I certainly would not have included it.
Okay,
But
but
at the time,
now,
I did.
right, but now when I'm then asked to look at it and then try to make a determination as to whether or not there would be the appearance of bias, I can't say, gee, they said they shouldn't have put it in, so I'm not, I can't do that.
I understand.
Okay.
But it's our position that the standard, as laid out by both Herrick and Pluffle, is not an appearance of impropriety. It's included in here because that is part of the analysis, but it's not the law. This court is directed to look at whether or not there is an actual conflict. And the actual conflict has been defined as being either in one of two categories. Is there a former attorney-client relationship between the parties? Clearly there's not. Or is there a situation where the prosecutor has an interest in the outcome, whether it is emotional or religious, as the defense has claimed? I would submit that it's not.
Judge, I would object to that because nobody has mentioned anybody's religion except for the attorney general.
It's in the report.
Well, I think I did.
Have not mentioned.
So look,
But to throw
I note the objection, and I'm just gonna say, look, I am not gonna be paying attention to whose religion is what, because frankly, for the most part, unless you tell me, I have no idea. Nobody knows what my religion is, right? So I can't pay attention, and I'm not gonna make a presumption about what somebody's religion is, or if they have one. It's irrelevant to me. Right, I mean, so it's noted, but I'm gonna let people argue. Go ahead.
Thank you. So in their reply, they really narrowed it down to 4 issues. Whether or not the AG bypassed the local prosecutor, which I submit to you, we did not. It's my understanding that there were 4 felony cases that were charged by Prosecutor Savitt at some point in the fall of 2023. And then it's in May that I write the letter to say, hey, if you want help, we're here to help. There is no solicitation outside of the normal course of business. That happens, as I previously stated, all of the time. We offer services on everything. They cite to a higher charge rate. Now, again, using an article that I think is false, what I can tell you, because I have no idea how many warrants were sent to Mr. Savitt's office or how many warrants were sent to Prosecutor Worthy. What I can tell you is that there were 7 different incidents that were sent to our office for prosecutorial review. There were 37 suspects and we charged 11. So the numbers that are cited by the Guardian, we've repeatedly told them are incorrect. We've provided them with the correct numbers and they refuse to change it. 2 of them have been resolved by way of plea, 2 are charged with trespass, and the remainder are here. So whether or not that is selective prosecution, I think I've already said that I believe every prosecution involves prosecutorial discretion. Public statements that are critical of pro-Palestinian figure, that being Congresswoman Tlaib. Again, there were posts about this statement of from the river to the sea and what it means to certain groups of people. The statement today that AG Nessel has never said, I'm supportive of pro-Palestinian rights. I don't understand that argument in the sense that she has said everybody has the right to say what they want. Even repugnant things. If it was the right, those folks have the right to say that, even if I disagree with it. And what she has always consistently said is that peaceful, lawful, permitted protests are within the bounds of the First Amendment, and she encourages that, particularly given our political climate. And finally, we talked about the Hamtramck spa. They are factually very different. She protested them publicly. She has not done any of that here with these defendants. There is nothing on this record, I don't think, where they can point to that she has an interest that rises to the level of the standard, which is an outcome that is personal, financial, or emotional, either in the case or with the accused. There's nothing on this record to show that she has.
Counsel, that's where I'll be honest with you, you're kind of losing me. And I'm going to go back to paragraph 6,
okay?
Because in paragraph 5, you're right. Paragraph 5, you talk about the Hamtramck case. when I get to paragraph 6, in paragraph 6, the U of M protester cases are brought up. But then what ties it together is that last sentence in paragraph 6. And I'm trying to figure out why the Attorney General is not acting the same way with regard to Hamtramck as to these cases, because this is what's said. It is likely similar criticisms would be raised if the prosecutions were brought here as suspects 1 through 5 are of Arabic descent. See, to me, that's saying, look, I'd be criticized for that. I'm being criticized for that in these cases. So in the Hamtramck case, I'm recusing because there is that criticism and I want the appearance of fairness. But then it goes further to say it is similar to. These aren't my words. This isn't my conclusion. It says these are similar to, that you tie the two cases together in the sense of what that perception is. And so it's hard for me, and maybe you can help me, to get to the point that if I'm recusing because I have some bias or perceived bias in these cases, and I think that that perception of that bias is or that criticism, that bias, whatever it is similar to these cases, then why, particularly as a prosecuting official, why wouldn't I deal with them the same way?
These cases don't have that added fact that the Hamtramck case, and that is listed in paragraph 5. There is not that public protest. That is the first basis.
It is likely similar.
It is.
Criticisms would be raised if the prosecutions were brought against these suspects, not because of the protest. It says, as suspects 1 through 5 are of Arabic descent.
Yes, because that is what she is consistently hearing, is that these prosecutions are based on the speech and who they are. And it is likely that that would have been the same thing that would have happened with the Hamtramck case. And again, it is a distraction. I think it's a distraction here, and it would be a distraction to those.
But then why wouldn't you treat them the same? Why wouldn't you say, if I'm going to recuse because of that in those cases, why wouldn't you do it here?
This case doesn't have that extra protesting that she did against those specific defendants. I believe that is what makes this different. Thank you, Judge. I've heard it said a couple of times that defendants are entitled to a neutral prosecutor. I don't know that I've ever been neutral on any of the cases that I've ever prosecuted. And I don't think that that's a fair standard to apply to any. Anytime you put on the paper and you charge someone with a crime, whether it's a misdemeanor or a life offense, you understand as a prosecutor that your duty is to seek justice, and you follow the evidence no matter where it goes. And that is what we have tried to do with these cases and with every case that we appear in front of. I would submit that the AG does not have a conflict in this case, and we should be allowed to continue.
So I'm actually in a response to guys, okay?
That's
Fine. Okay, so some of the issues that were raised was that in the Hamtramck case, there was a public protest by the Attorney General, and that's the difference here. But in this case, there also was a public protest by the Attorney General when she called press conferences with other politicians, specifically to go after the phrase, "From the river to the sea, Palestine will be free." Because that is a phrase that these protesters and just about every protest demanding Palestinian rights going back decades has used. Attorney General Nessel, I think State Senator Jeremy Moss held a press conference where they say that it is an anti-Semitic and it is a battle cry for those who want to kill Jewish people. Dana Nessel then said at the press conference, those words are anti-Semitic to us. And it looked as if she was holding back tears. And said, it is still painful. It still hurts us. And there is video from this protest of these defendants using that same phrase that Attorney General Nessel called a battle cry for those who want to kill Jewish people. Anti-Semitic words that are still painful and hurt us. And she's gone out of her way time and time again to attack the only Palestinian American member of Congress for nothing that concerns the duties of the Attorney General, but she has held these for what? To criticize that Congresswoman's speech. That is the same speech that these defendants engaged in. And yes, I think we should look at the letter that they wrote for Hamtramck. Because as the court points out, paragraph 6, they chose to include it. They can't say, well, hey, we had one standard in Hamtramck, and then, oh, by the way, you know, it was a mistake on our part to include that paragraph because we didn't realize it was going to mess with our prosecution in Washington. Because that's what's essentially being argued here is, well, maybe we didn't need to include that. Could we ignore that we did? Could we forget about it? Because now it's come back to bite us here in Washington. It doesn't work that way. They filed this in court. They signed it. We only know about it because the Detroit Free Press reported on this case. That's how we found out about it. We don't know anything about Hamtramck. And the fact that those individuals were protesting on another issue, those individuals, the Attorney General protested their positions on gay rights and the waving of a gay pride flag outside City Hall. And the Attorney General points out today that, yes, I mistakenly referred to them as Arab. They're actually from Bangladesh. I'm assuming they might be Muslim. Judge, we don't mix this all up. We don't, I don't know what their views, I don't know what the relevance is of those individuals being, even if they are Arab, all of them, or some of them are Arab, and some of them from Bangladesh, or if their religion is Islam. I don't know what bearing that has on this case and why this case was mentioned there. I don't know what those Arab individuals and the individuals from Bangladesh, what their views are on the Israeli-Palestinian conflict. I don't know if they agree with the Attorney General's position about from the river to the sea being an anti-Semitic battle cry for the elimination of Jews. I don't know what their positions are, but the Attorney General felt that they're all together. Those Arabs and those Muslims in Hamtramck and these kids protesting for Palestinian rights in Ann Arbor, they're all the same. If I'm biased against some, I'm biased against all of them. That's the position they took. And it's not right to now just come here and ask to ignore it because one party found out about the argument they made in about another party. And so, Judge, I'd argue that the Attorney General's insistence on multiple times going out of her way to attack the speech of Congresswoman Tlaib that is identical, and we see it on video, to the speech that is being exercised by these individuals. That is the equivalent of what she did in Hamtramck by specifically protesting those council members and their views. Because these defendants' views are identical to the views expressed by Congresswoman Tlaib that the Attorney General called an anti-Semitic battle cry for the death of Jews. That shows the emotional connection that when she appears to be holding back tears, saying this hurts us, this is painful. It's a battle cry to kill our people. That is the emotional attachment. And then you combine it with essentially a solicitation of a criminal case to send a letter to the University of Michigan and said, hey, I already took it upon myself to speak to your local prosecutor. And it would be great if you submitted these cases to my office and not his. And I'll tell you what the difference is. Because when he prosecuted these cases, the way in which he handled them was not sufficient for people emotionally invested in this case, in this type of issue, such as the Attorney General and the individuals on the Board of Regents of the University of Michigan. What did he do? He reduced felonies to misdemeanors immediately and entered into agreements for probation under HIDA for some. Others, he agreed to diversion, which resulted in a full dismissal. That wasn't the, that didn't, meet the standard that individuals like Ms. Nessel and others that wanted these students' speech criminalized, they weren't satisfied with that outcome. And so that's why the next time this issue came up, we bypassed Prosecutor Savitt and we go to the Attorney General's office. Judge, this court has been practicing long enough. Just common sense. We don't see the Attorney General's office in here on misdemeanor trespass, 30-day trespass misdemeanors. But some of the two defendants are facing that charge alone, charged by the Attorney General's office. Or even this low-level felony resisting obstructing arrest. That is not the type of case that we typically see the Attorney General's office in courts ever. Let alone before any case is submitted, before any evidence is gathered, sending a letter to the university saying, hey, I'm an expert at finding the right balance between free speech and criminal laws. I'm your office. Send them here. And was mention made of prosecutions in Wayne County. I actually represented some individuals prosecuted in Wayne County. The officers in Detroit, Wayne State University police officers wrote tickets. They actually issued misdemeanor citations. And so these individuals went to court, and then upon review by Prosecutor Worthy, she said, I looked at the video, I looked at the evidence. These kids were exercising free speech. I'm not pursuing these charges. And she instructed the assistant prosecutors to dismiss those cases. But those cases were filed by criminal complaints initially by the police officers, then the prosecutor's office refused to go forward. The Attorney General's office talks about the multi-jurisdictional allegations. This is the only jurisdiction right now of any criminal cases regarding Palestine speech in this state, as far as I'm aware. There are no other cases where the Attorney General's office has filed in multiple jurisdictions. There's no other jurisdictions with this stuff pending. And we look at other issues. Judge, this is not the first issue that people protest, and it won't be the last. People have protested about the environment. They protested Black Lives Matter. I represent individuals that were prosecuted when Black Lives Matter protests took place. Those were all handled by the local prosecutors. I represent individuals in Lansing, others in Detroit. It never reached the level where the Attorney General's office said, hey, I will handle protester cases. Only on this issue. And it happens to be the issue where time and time again, she goes out of her way to criticize this speech and people's positions on this issue. For what? For demanding that people from the river to the sea will be free? What else should they be? So, Judge, with her filing the petition in Hamtramck, with her public statements, all of this, and the letter soliciting the prosecution, we don't look at any one of these things in a vacuum. Look at the totality of their circumstances. There is, if not a bias, an appearance of bias, which the Attorney General acknowledges in a filing made in another court of this state. And we can't just ignore it because now they wish they never wrote it. They acknowledge it. And it is part of the reason they asked for recusal in Hamtramck. And if it was enough for them to seek recusal in Hamtramck, it is enough to recuse them here. So we ask that you recuse the office of the Attorney General and appoint a special prosecutor based on either the actual bias or the appearance of bias that they acknowledge themselves.
Judge, I just wanted to respond to two quick things.
Yeah, well, and I have a
Do you have any
question.
questions for me, Judge? I didn't mean to walk away. I was putting my
Pardon? No,
I didn't know if you had any
no, I'm good. I'm just, but I have a question, and I'll certainly let you respond with whatever you're responding to. And it goes back to paragraph 5 and 6.
Okay.
If the recusal in Hamtramck was solely about the protests that the Attorney General had been involved in and the criticism, why is there any mention of someone's ethnicity, nationality, their race, their religion? Why does it, if I take you for what you're saying, that's the reason for the recusal, I don't have to say anybody's Arab. I don't have to say anybody's Muslim. I don't have to say any of that, because on the face of it, I was critical of these people, and so therefore I shouldn't hear the case.
Yeah.
That would have been it. But that's not what this says.
Right. It was included because it is the charge that has been made against Attorney General Nato for having brought these cases in the first place. She has been accused of Islamophobia. She has been accused of having a bias against Muslims. She has had a bias against Arabic, of people of Arabic descent. And so that's why it's included. It is only because I wrongly, obviously, I've already said, wrongly believe that the folks in Hamtramck were of Arabic descent. They're not. They are Muslim. At least that's what our investigation has said. And so that's why it was included. In terms of this SPA process, I keep hearing this phrase, it got filed in court. It got filed in court. The SPA petition does not get filed in court. Under the statute, when a prosecutor, the 49.10, when a prosecutor says, I have a conflict, they fill out this SPA form. It goes to the prosecuting attorney's coordinating counsel along with the police reports, where then it comes to me and I get to look at it and say, yep, prosecutor in Ontonagon County has a conflict on this case. Heck, send it someplace else. Send it to another prosecutor. Or I can say, you know what? That's a case that the AG's office is going to take. And the AG's office will take that case out. Of the, I don't know, I think we're up to like 500 already this year because there's just been an inordinate amount of SPAs. Our office has taken over 100 of them. 100 cases we've taken through the SPA process alone. But it never gets filed in court. It never gets filed with anyone other than my office and the prosecuting attorney's coordinating counsel as something to be able to send on to another prosecutor's office to say, hey, would you take a look at this? Because there also is no ability for me to be able to say, you know what, Muskegon County, you're taking this case, or Washtenaw County, you're taking this case. It is a process by which the prosecutors have to decide, you know what, I'm going to take that case for Washtenaw County or for the AG's office. That's how that process works. And so I just want the record to be very clear that this isn't something that gets filed in court. It gets drafted by the prosecutor or some of their staff, in this case by me, and sent to the PAC to say, hey, can you find something else with this?
I get that. But the statements in it are no less binding.
Sure, no, I agree.
Okay.
I agree. In terms of these cases that Prosecutor Worthy dismissed, that she viewed the video and she dismissed, I think we can all agree that every situation has to be viewed independently on itself. I have not seen those, but what I will say is that if we truly are vindictive and we have a personal emotional interest, because I love it when you say that a woman's being emotional. If I had an emotional interest to go out, I could go to Wayne County and say, you know what, give me those cases. Because I'm vindictive and I'm going to selectively now prosecute those cases that were dismissed by Prosecutor Worthy. That has not happened. That has not happened on any of these. The cases that we've looked at are the ones that have come directly to our office. We never bypassed any prosecutor. We never overruled any elected prosecutor's previous charging decisions here. So I just want that to be very clear.
So, okay, but that then begs the question, what was happening with these cases here in Washington? In your, what? There's these 4 cases that we know about that were charged.
In the fall, I think of 2023.
Right.
Yep.
Then there are these 7, and I think there might have been some other one. Anyway. So were these cases just sitting for somebody to come along and grab? I mean, what was happening here to these cases?
I don't think anything was happening to them. I think they were still being investigated. I think they all happened, again, I think, don't Don't quote me on the timing, but I think they all happened fairly quickly. An honors convocation, a graduation ceremony,
Right.
events at the art museum. I think they all happened relatively close in time. They all get investigated. I send a letter to U of M to say, hey, I understand you have control over your police department. If you want help, you can send him to our office and we'll take a look at him. I've talked to the prosecutor, so I don't want to make him mad. I don't want him to think I'm coming in to just take his cases, because again, I've worked really hard over the last 6 years that I've been in this position, and previously I worked for PAM, which is a subgroup of the Prosecuting Attorneys Coordinating Council. I worked really hard to develop relationships with prosecutors, so we don't do that. That's what's happened as far as I know. Hey, you want our help? We're here to help. There isn't some backdoor, we want to be heavy-handed. We're looking at the cases, we view them, we decide whether or not the evidence fits the law, and then we make an appropriate charging decision as we see fit. We then send them to a magistrate, and an officer has to swear to the probable cause for it. If there wasn't probable cause, they never would have gotten issued in the first place. We're now here past exam, where this court has had an opportunity to hear all that testimony, has given defense counsel an opportunity to brief these First Amendment issues, as far as I know. Again, I wasn't here for the exams, but an opportunity to brief these issues, have us respond to them, and then ultimately make a charging decision. If these were wholly without merit, I'm sure this court would have dismissed them after the exam. But we're not at that position.
Okay, I still am at a loss as to where these cases were. Now, it may be after some 40 years or 26 years sitting on the bench, I'm just ignorant of the process. But it seems to me the police file their requests for charges with the prosecutor. So as I understand with these 7, that was done with our county prosecutor.
Sorry, I don't understand what you meant done with our, like, asked him, hey, do we?
Yeah, they send over and they're requesting charges. They send over their report and they want them requested. Certainly when I was a prosecutor way back, that's what would happen. The police department sends a report, you're looking at it, you make a decision as to whether or not it should be charged. So I'm gonna, well, and maybe I shouldn't make the assumption. Is that what happened here? And then there wasn't a decision by the local prosecutor?
There was not a decision by the local prosecutor, because I remember that there was a report that said these were all denied by the prosecutor, and then they were sent to our office. That's not true. I know for a fact that there was no charging decisions made by Ellie Savitt in his office. The phrase he used with me was he administratively closed them and had the law enforcement officer bring them to our office.
What is that?
Judge,
Yeah.
as far as whether a decision was made by Mr. Savitt or not, they preemptively wrote the letter on May 24th saying, give them to us. We want to prosecute these folks. And all they know about them at that point is that they were engaging in advocacy for Palestinian rights. That is all the Attorney General knew on May 24th when she wrote this letter saying, hey, forget Eli Savitt, send them here. And it begs the question, why did it not happen on any other issue?
Why, but hold on a second. When you're saying preemptively did it, what do you mean?
There's a letter there, the letter that they submitted a few days ago, I think 2 days ago, they submitted this letter that they sent addressed to Mr. Lynch of the University of Michigan.
I recall that letter, yeah.
Right, and so.
I'm trying to figure out why you're using the word preemptive.
Because the conduct happened on May 21st. From the court knowing the amount of video and everything that we've all had to go through, Mr. Savitt would not have reached a decision by May 24th anyway, right? And so.
I see what you're saying.
This letter is sent saying, hey, Mr. Savitt, do you really want to go through all this video? Why would he? Fine, you want to take it off my hands? Have at it. And so it's not, and you know, Judge, if combined with the pattern of criticizing Palestinian Americans and those who advocate for Palestinian rights, to then, you know, on your own, send out this letter saying, hey, if you want to prosecute these guys that were talking about Palestine, you know, we're your office. Send them here. And what I would say is if these were Black Lives Matter protests, the Attorney General never got involved in prosecuting any of those, as far as I know, right? But if we had an Attorney General who had made racist statements and criticized people protesting for Black Lives Matter, and then within 2 days of a protest, sending letters saying, hey, if you want to prosecute any of these folks that were involved in Black Lives Matter, send them here. That shows the bias. And that's what took place here. She spent a year going on TV criticizing Palestinians and then says, give it to me.
I don't jump to the same conclusion that necessarily shows bias. Because I'm more looking at process. More so rather than what you're purporting to be General Nussel's statements. I'm more worried now that you pointed out to the court about this 3 days. Because that's a real short period of time to do anything. And it even highlights really what my difficulty was when this all started, when I was reading through everything over the past few days. Something happened that I can't see when I look at that letter. And it makes it even more curious for me that it's only a 3-day period. Something happens on the 21st. Most of the time, quite frankly, there are reports written up that are going to go over to the prosecutor unless it's something by that time. But okay, 3 days later, I'm presuming there was a phone call to Mr. Savage, which you've indicated.
Right.
And then this letter is written. What happens in those 2 days?
I don't think anything happened because defense has got you focused on the day of the encampment because that's why we're here. But that's not the only thing that we looked at. We had the honors convocation, which
occurred before.
Which occurred before. I'm not going to lay down and say that this is the day, but I understand that graduation is coming up, and I assume having graduated from a college, they tend to have them around the same time every year.
Yeah.
So I would think honors convocation probably end of April, beginning of May. Graduation is May. So there's the honors convocation event, there's the art museum event, there's the graduation event, and then there's a couple of events that occur during the encampment, I think, that are related to the destruction of the flags that actually get charged. We looked at all of those. We reviewed 37 warrant requests for these individuals and landed on just the ones that we've already talked about. So I'm not sure that focusing on 3 days or 2 days or what have you is the appropriate time frame. If you look at all of it, all of that is happening in April and in May.
Okay, so let's do this. Let's say it's a month. What happened during that month?
All of those things. The honors.
No, what I'm saying is, what happened to cause the letter to be generated? It can't just be the phone call. It can't. And maybe what Mr. Macklin was inviting this court to do, although at some point I got to get through this case, get a life back. But we may need to hear from Prosecutor Savage about what happened, because I'm not getting an answer about what occurred. I got the defense saying it's 3 days. You're saying it's not 3 days, but it's a relatively short period of time. But nobody can tell me whether it's 3 days or a month, what the heck happened. I don't know. Everybody's giving me their explanations of it, but I just don't know. And nobody seems to be able to answer for me what these cases were doing, that they were just sitting. Okay, that's been known to happen.
And there was no case. That's what we're saying. We're saying there was no case until the Attorney General said,
No. When I say a case, I mean the request for an authorization from the police department. So there's a request for authorization that's coming from the police department to the prosecutors.
Right.
That request for authorization, I don't know what day that happened on these cases. I don't know then, once that request came in, and I keep saying it over and over, but I don't think anybody knows, which is why I'm not getting an answer. I don't know what was happening with those requests for authorization. Were they just sitting on somebody's desk doing nothing? Or was somebody staring at them? Was somebody about to do something? Was somebody calling around saying, we're not touching these? I don't know what anybody was doing. So, go ahead.
I'm sorry. I have an officer in charge who knows more about timing in terms of when warrant requests were presented. It's my understanding from having a quick conversation with him that there had been some of these events like the honors convocation and the graduation that had been prepared and sent over, and they just weren't doing anything. And then the encampment case never went to prosecutor Sabat. It just came to our office because at that point, as the letter says, there had been this conversation with prosecutor Sabat where he's like, feel free to take them.
So, okay. So now I'm getting kind of confused. So these 7 never went to prosecutor Sabat's office?
That's my understanding.
That's from what they're saying, yes, and it makes sense because before they had a chance to get to prosecutor Sabat's office, they got this letter from the attorney general saying, send them here instead. So it sounds like is they were never sent to Sabat. They were sent directly to the attorney general in response to her letter soliciting the cases, which is dated May 24th. The report has been completed.
Can I? So why did, and maybe you don't know, I see the letter, but why did that happen?
Because we understood that there were these cases and that there is definitely that connection between the First Amendment and between crimes. And we have that specialization and we have the ability to be able to do the review. So we offer, just like we do in hundreds of other cases.
Maybe I'm not too smart, but isn't that strange? I think because, no, hold it, because at some point I have cases that are really gonna have these First Amendment things. Those cases get to the county prosecutor because they authorize. These don't, as now I'm to understand, I'm assuming those never make it there.
These defendants, their cases were brought directly to our office.
Why? I mean, but that's what I'm asking. Yeah, you can send this letter, but if I'm a police agency, this is where I send my stuff. And then why? Whose decision was that to do that?
Decision to do what?
To send them to the attorney general.
Ultimately, it's the police department. No matter what crime you're talking about, whether it is a murder case or a drunken disorderly, the investigating agency decides where they take it.
Okay, so why did they change gears? Why do I send some to the prosecutor here in Washtenaw and then all of a sudden decide with these infamous 7, they go elsewhere?
They're not just these 7, Judge. So everything that had previously been sent and everything afterward then came to our office. So again, there were cases that had been submitted by the police department to Mr. Sabat. He authorizes a couple of them in November, and then there's more that come, I think probably at the end of April, beginning of May, and there's no review done. The letter is written, and then all of those cases are, quote, administratively closed by Mr. Sabat because he says, send them to the AG's office, and then all of them.
Okay, so hold it, folks. Again, Apparently you're confusing me because I just heard, and maybe I heard it wrong, that these 7 cases never made it to the county prosecutor.
That's right.
So if that's the case, what is Mr. Savitt administratively closing?
All of those other cases that had already gone to him, that the honor, I think it's the honors convocation, the museum, the graduation, those ones all get closed and all of them get transferred over to our office.
Judge, all of these cases are about May 21st. I don't know about honors convocations or anything else, but everybody here in front of you is from May 21st,
Oh, I recall.
right? So we're throwing out other days, but.
So there's been this big argument about the, selective prosecution and how we've charged 85% of the cases. That's just simply not true.
Right, okay. I get some of that. I do. What I'm not getting so everybody's in agreement, these cases never went to the Washington County Prosecutor's Office.
We accept that representation by the Attorney General.
All we can do is take their word for it. We have nothing to indicate otherwise.
Okay.
Right.
So then the question becomes, what causes the police department to not send cases where they would normally send cases?
The letter, the May 24th letter.
But I
Send them here.
don't, do I know that?
Oh, I'm sure you do.
Well, no, I mean, but I haven't heard that. I mean, I don't know that. Do I know that the police agency saw that?
Judge, I think you could safely say that if Prosecutor Savitt wanted these cases, he would have told his agencies, bring them to me. And if he didn't want them, as he sent them to us.
Well, no, I don't know that that's the case. I think that he would have to assume that the cases would have normally come to him. And then if they weren't coming to him, he would have said, whatever, but I don't. Mr. Reddick.
I don't know if it matters to your consideration, but it would probably be relatively easy to establish when the police reports were completed and when they were received by the Attorney General. My memory from the discovery is that the reports were some days after this, that may not have even been the same month. I don't recall when the reports were finished, but I believe it was well after this May 24th letter. That may not be dispositive here, but I think it does put a gloss on the connection made by the Attorney General between the Hamtramck cases and this case, as you noted in paragraphs 5 and 6.
How fast can somebody retrieve those dates for me?
Do you have them here?
Of when the reports are finished and submitted? I mean, you say it might be in your discovery?
I don't know. I think Officer Jerry's looking at like this person.
Judge Graham.
Oh,
the date
right.
that you discussed.
Pardon?
The question, the date that the review was submitted to the AG's office?
Yeah, when the reports are finished, when they were submitted to the AG's office, and then I guess we would kind of know when the charging happened, but also if we have that date of the charging, I mean, those 3 dates seem to be critical. Let me also say, Madam Attorney General, the microphone there is hot. So to mute it when you're talking at the table, you'll have to hit it. It will turn green and, okay.
Oh, okay.
Okay, so that,
My apologies.
no, not a problem.
Okay, so.
All right, well, they figured that out, folks. I'm gonna take about a 10-minute break because
I do have one.
my
report.
head's hurting, but you're not gonna let me do.
I'm sorry, I'm sorry.
No, go ahead.
Well, listen,
Fine, no, it's okay. The comfort of the judge doesn't matter to anybody. Go for it.
You were asking about the dates. I found a report that said May 22nd. That's all. That's all.
May 22nd for,
It was written at 12:13 a.m. That's.
when the reports were written.
It's
Okay, then it's the
but also-
other two dates that then become critical. All right. Folks, you're gonna have to give me 10 minutes. Court's gonna stand in.
14 Egg District Court, for County of Washington, State of Michigan, is now back in session. Honorable Judge Jay Simpson.
You may be seated. This is gonna be like hunting squirrels. I got everybody?
Yes, sir.
All right, back on the record in the case of the People versus Willow. All right, counsel is present. Were we able to figure out those dates?
Yes.
Okay, go ahead.
I have that this case was submitted to the AG's office on June 13th, and charges were announced on September 12th.
September 12th. Does that comport with? So, all right.
We announced some September 12th date. We don't know about the June date.
I'm sorry. You don't know about the June date.
Well, now it's September 12th.
But I think for purposes of our discussion, the June 13th date is fine, even if it was an approximate date.
Got it. I have one question for the, well, two questions really for the defense. First one being, as I look at the dates of when things are occurring that you're relying upon, why is this raised now as opposed to some earlier point?
We only found out about the issue when it was. We only found out about the recusal of Attorney Dana Nestle's office in the Hamtramck case. As soon as we found that out, we immediately filed this motion. That was the catalyst of why we brought this forth. That hadn't been on our radar otherwise. And when the Free Press published this petition that was written by the Attorney General's office, at that point, we decided to file a motion to recuse and disqualify the Attorney General and ask for the appointment of a special prosecuting attorney. We only found out about that, Judge, within days of filing this motion.
Right. I know, Judge, that the petition filed in the Hamtramck case was dated March 10.
But I just note that it was filed, it may be dated March 10th, but we didn't know about it until it hit the Free Press, like maybe 3 days before we filed this motion. I think I found it in the Free Press, emailed it to the rest, and we went from there by the time we researched the law and everything. I think, we had an idea of everything else we talked about, these public statements of the Attorney General. But a lot of it, to bring the motion early on would have been more speculative. But once we had this petition combined with all of that, I think it gives us grounds to file a motion that we believe should be granted.
Hypothetically speaking, and I want to make it clear, the court hasn't made its decision. If I were to grant the motion in this case, how does the defense view the proceedings which have transpired thus far? Are we going to do another prelim?
We don't believe we're entitled to that. Mr. Minot can speak to that.
No,
yes.
No, I don't. We discussed this during the recess. We don't think that there would be another preliminary examination. There would be a change in the prosecuting official. And we believe that the Attorney General has correctly identified that process namely that it would go to the prosecuting attorney's coordinating council. And they, in conjunction with other local prosecutors' office, probably somebody peripheral to Washtenaw County, would select who was going to handle it.
It doesn't work that way.
No? Okay. I thought that tried to eliminate drive time.
So, Your Honor, the purpose of the preliminary exam is for the magistrate or examining judicial officer to be always of the same person at all times.
Yeah, no, I'm not saying that this court wouldn't be the same court. I'm not saying that they get another preliminary exam. I'm saying that PAC does not have the ability to say, Jackson County, you are taking this case. That's not how this works.
Of course, they would, the receiving county would have to agree to take it on.
Yeah, typically they're.
So it would go there and the receiving county would be the one to say, yeah, we'll take this.
That's right.
We have 83 counties.
You're right.
Washtenaw would be out. So of those 80,
Why would Washtenaw be out?
I don't know. Okay, let's say Washtenaw still in. So yeah, I guess Washtenaw wouldn't be out because they haven't even seen, according to.
They looked at the evidence. Nobody has.
That's assuming that there's no other reasons in their own judgment why they would accept or decline.
I think you have to recognize, first of all, that this has not been an easy lift. There are hours and hours and hours of video. There has been lots of media around it, and there are probably many prosecutors who would say, thank you, but no thank you. So I don't suspect that it would be an easy task to say, hey, take this one. Will it get placed? Yeah, eventually it'll get placed. Otherwise, we'd probably have to hire somebody to do it separately and independently.
And
I would disagree with the right prosecutor with the right.
well, I don't know that that's fair. Saying that.
I would,
And I don't, you know, look, people can disagree on things, but I don't. I really don't think that that comment was necessary. I am, you know, when I look at this, if what you want me to do is attribute some bad faith to the state's attorney general, I don't see bad faith. I see that there may have been something that is difficult to explain. But I want to, you know, and I guess maybe given that comment, I want to make it real clear. People can have their views publicly about a lot of different issues. But I think, as the Attorney General here said today, I've had cases where the Assistant Attorney Generals, under the direction of General Nessel, have come down and tried cases before me. And if I were to look at those cases, and the defendants look all different kinds of ways, and to try to say that somehow or another that there is some actual prejudice or bias, I'm not going to buy it. And I'm just going to tell you, if that's your argument, as I would say to anybody that's going to say anything about anyone having some actual bias against somebody, and then particularly a government official, because of that bias, acting in a particular way, well, you better bring it, because I think that's a high burden. And I'll make it clear, I've not seen that in anything that has come before this court, in any case that has been handled under under General Nessel. I just not seen it. And I don't even see it necessarily in this case. What I see in this case is what may be a perception. And sometimes perceptions take on a life of their own. But it doesn't mean that that person, because of that, that there's some evil or mal intent in that person. So, you can say all of that stuff, counsel, if you want, but those kinds of comments are going to fall on deaf ears with this court.
But did it mean, it's withdrawn.
Thank you. Because yes, you did mean disrespect, and it's not going to happen in this court.
Comments withdrawn.
All right. All right. Was there anything else anybody else wanted to say, which is like the judge's great fear to ask of a room full of 8 attorneys?
Respect the court's time and thank you for the court's opportunity to hear our arguments.
All right.
Nothing further.
Anything else? All right. There are a couple of things that I want to think about, and I think the court's was sort of leading to it. If the parties are in agreement as to the time frame and how these cases got there, then this court needs to think about what, if anything, that means. And I'm not going to be hasty about the decision. I think that the decision is a heavy one. Disqualifying a prosecuting official on that is an issue. And I want to the best of my ability, make the right call. The other issue, though, that I have is paragraph 5 and 6. And as succinctly as I could put it, if, as the Attorney General has indicated, the reason for the recusal in the Hamtramck case is because of public criticisms made of those council persons. And I'm not entirely clear that part of that can't be true. But then there would be if that's the reason, there's no necessity for paragraph 6. There is then no necessity for the mentioning of anybody's religion, race, ethnicity, anything along those lines. And I want to make sure to give everybody an ample opportunity to tell me. And so I certainly have heard the argument today. And my intent would be to reconvene on, I know, Ms. Askew, you said you were out for a period of time in May.
Correct, yes.
But I have the 5th of May because I want to make this decision as soon as I can. Either way it falls. You're still okay. So I would. Will everybody else? Can everybody else be? May.
I'm sorry, but it is the Indigenous Peoples Day, and I'll be in Grand Rapids in March recognizing MMIP work, and so I will not be here. If you need me specifically, then ask for a different day. If I can send a colleague, I can certainly do that.
Okay, why don't we try to do it this way? Because I really do want to get this, and I think she has told me I lose Ms. Askew most of May. So I'm just trying to work that out.
Are you thinking the afternoon on May 5th?
I think it's the morning. Morning. Is that a problem for you?
I have a matter in Bloomfield Hills.
No way.
I'll
No, I'm kidding.
reach out to them, trying to adjourn it. I don't think I have a problem adjourning.
Okay. Here's what I'll do, Madam Attorney General. I will allow, because part of the issue for me is going to be, and I've heard the argument, but paragraph 5 and 6 are causing the court great problems. So I certainly will allow anybody to submit to the court. I don't need it in response to each other. Anything by the 30th of this month for the court's consideration regarding that basic issue, if you feel the need to do it. I think the court has a great grasp on it, but I want to make sure anybody that wants to tell me something gets to tell me something. Okay. And then if you could send somebody else, I'd just like to get this done. So we will do that. Counsel, you know, one of the reasons, I guess, in a lot of ways, I'm proud to be a lawyer is because sometimes when you get good arguments from counsel, it just gives you a great deal of gratitude for the profession that I've chosen to be my life. And you guys have done an extraordinary job of presenting the issues, answering the court's questions and the like. I wish I could bring a group of younger attorneys who seem to have a lot of problems with answering court's questions in to see how it really should be handled. So I thank you for that today. So we will adjourn for the decision on this case to May 5th, 2025, 9 a.m. Thank you.
Thank you, Your Honor.
Court stands adjourned.
And there you go. What the judge said there at the very end is the very reason that I wanted to put this little presentation together and let all of us watch it together. If for no other reason, if there are some law students out there, this is the way it's done, ladies and gentlemen. These people did not agree with each other. They were at each other's throat the whole 2 hours that we were watching this. And we didn't even come out of the hearing with a decision. But ladies and gentlemen, that's the way a legal argument is fought in the real world between knowledgeable attorneys who actually know their profession and can actually make cogent arguments in front of a brilliant judge. Ladies and gentlemen, I am your Lone Wolf Usul. I bring these little things to you for the court gallery repository. We do this weekend court review every Saturday at noon Eastern time. Come by and hang out with us. But if you want to participate in the little live chat we have going on, we do that every single night at 8 p.m. Central Time. That's 9 p.m. Eastern Time, where we look at Judge Fleischer's daily docket of the day. And if he's not on, we'll find somebody to watch. So come by and hang out. Chat with the chat and do the things we do and enjoy the court gallery that we have available to us. Ladies and gentlemen, it's been a wonderful morning/afternoon. Chat's been awesome. Thank you for being here. I'll see you next time. I'm your Lone Wolf, and I am saying I'm out. Have a great weekend. More videos to come. Danny, no, it's not okay to disagree. You can only disagree, and that's okay if you want to disagree. But it's not okay if you want to disagree, as long as you disagree. But we agree about disagreeing. Y'all have a great weekend.